At CaseyGerry, as a managing partner, one of the things I'm very proud of is how our team works together. And in a recent case we had, that synergy really worked. We had a situation occur that was very tragic, where two young girls were visiting their father in a home in San Diego. And late in the night, at 2 or 3 in the morning, their father was downstairs after drinking, and he turned on the fire and he put kerosene on t-shirts and threw them into the fire. Unfortunately and sadly, the home caught on fire, and one of the girls was burnt to death because of the father's negligence. We were contacted by the mother. The mother and the father were divorced. The children had been with the father that night, but regularly lived with the mother, to see if there's anything we could do about bringing in action for the death of her daughter against the father. That was a very unique and challenging circumstance. They noted, we have a family exclusion. This is a daughter of the father. She was a resident there. There's no basis legally to make a recovery. That's when I brought our team in to really look at it in depth.
When David asked me to look into this case, the primary issue as to why there was no coverage was that the daughter was a resident, and both daughters would spend about 25% of their time at the father's house, which included the location where the incident occurred, and then about 75% of their time with the mother. So when I dove into the case law to try to establish that this particular provision in the policy would not actually apply here, there was a lot of case law surrounding children with divorced parents and how the courts actually look at whether or not the child would have been considered a resident under this type of policy language. So this really was helpful for us because we had sufficient law on our side and evidence from the mother establishing that her primary residence was with the mom, and this was very helpful for getting them into that place to ultimately pay off the policy.
After I got Samantha's analysis, we then again demanded that they respond. They ignored us. And so at that point, after talking to the client and explaining the challenges involved, we decided that we would go forward in litigation and we would bring a lawsuit. But our litigation team, made up of Samantha, Jason Evans, and Noah Moss, filed this action. And when we filed that action, they prepared very detailed requests for admission.
There's a new law in California that just went into effect January 1st, 2022. And that law, it says that the family members of somebody who's been killed, they're entitled to recover compensation for what that person experienced in the moments leading up to their death. It allows families to recover compensation for their family members' experience of dying. And so that presented a big challenge for us in this case. The young girl, 9 years old, who died in this house fire, she was autistic and she was afraid of fire. And so we had to do the work to get down to what was that experience like for her. And what we did was what we do in every case. We spent a lot of time with the family to try to understand her and to try to understand what she meant to the family that lost her. We talked to the mom, we were lucky enough to talk to the younger daughter, and we really tried to understand what that experience was like for her so that we could effectively communicate it to the other side. And so that's what we did. And it was a team effort and it took a village. And ultimately, we were able to succeed. We prevailed in communicating to that insurance carrier the magnitude of what that young girl experienced.
Because of the extensive groundwork that we had done before even filing the lawsuit, we knew in the discovery phase what we wanted to prove factually and legally. Ultimately, over 2 years after the incident occurred, the insurance company had to agree to our final demand, our policy limit demand, for $6 million.
When we first were looking at the issue of the resident relative exclusion in this case and the position that the insurance carrier was taking as to why the insurance was not applicable, we really collaborated as a team to kind of assess and understand what this provision actually meant, how the law applied here, and whether or not they could actually succeed if they decided to bring an action for declaratory relief, for instance.
For over 2 years, it looked like the recovery could be be zero. And then on the very last day of our deadline and our demand, we were able to secure the maximum settlement for our client that was available of $6 million.
At the end of all of this, we were able to make a $6 million recovery, which was the full limits of the insurance policy for this family that will now make a big difference in their life. It will never replace the devastating loss of this young woman's daughter, but it begins to allow her to move on with the rest of her family going forward. At CaseyGerry, we very much pride ourselves in doing the best job we can for our clients. And in this particular case, I would like to think we acted at the very highest level in the legal profession, taking on a case where we were basically told by a major insurance company there was no case, there was no ability to make any recovery, yet we succeeded in achieving one of the larger results in a wrongful death action in the history of San Diego.